Next, I have Bernie Jimenez Gomez.
Your Honor, we'd like to be heard as probable cause in this case.
All right. For the interpreter, this is 2025 CF 120. I'm sorry, 124050. Public defender wishes to address challenge probable cause. Give me 1 moment. This is pursuant to a warrant signed by Judge Madrigal charging the defendant with throwing a deadly missile into an occupied vehicle and criminal mischief. Can I get a copy of the affidavit supporting arrest warrant? All right, sir, you may proceed.
Understanding that as to the throwing charge specifically, I believe the statute requires as an element to prove in a case the allegations in this case are Ms. Gomez threw an unidentified object that caused crashes and small dents on the car. That alone is sufficient to satisfy.
The clerk is going to be printing the affidavit in support. Are the facts going to say that the owner of the vehicle or that the victim was in the vehicle at the time? State your response.
That probable cause has already been found, Your Honor. The defense has not produced any new facts. It is based solely on the affidavit that has already been reviewed by a judge, and probable cause found on those facts. Any other argument, Your Honor, is then a defense to what has already been found.
All right. I've now had an opportunity to review the affidavit for the arrest warrant. As I said earlier, the arrest warrant was signed by Judge Madrigal. He found probable cause. I don't believe that I have the authority to overrule probable cause finding of the judge that signed the warrant, which brings the defendant before the court today. I have reviewed the charging affidavit. I do find that on the four corners of the affidavit, notwithstanding whether I have the authority to do so, there is sufficient probable cause facts to support that charge. So I'm going to deny the probable cause challenge. I'm going to find probable cause as found in the original arrest warrant. State what degree of crime is throwing a deadly missile into an occupied vehicle?
I apologize, Your Honor, I didn't hear you.
Sure. In establishing monetary bond.
Oh, it's an F2, Your Honor,
F2.
so $7,500.
Okay. All right. All right. And then Mr. Jimenez Gomez has requested that I appoint the public defender. He apparently does not qualify. Mr. Jimenez Gomez, this indicates that you have no dependents and you earn $800 a week. Is that correct?
See.
Right.
Yes.
I'm going to find that he does not qualify for the appointment of a lawyer. I'm going to set bond on count one in the amount of $5,000. I'm going to stay the bond on the criminal mischief in the amount of $1,500. The total will be $6,500. Special conditions are no alcohol, no drugs without prescription, no weapons, no firearms, no contact directly or indirectly with the victim or witnesses. And I think that should do it. Good luck, Mr. Gomez. Are those all the Spanish cases? All right. Thank you, Mr. Interpreter. Have a good rest of your day.
That's a pleasure, Your Honor. You do as well.
All right. All right. Is this Mr. Brian Brown?
Correct, Your Honor.
All right. Mr. Brown is accompanied this morning by Mr. Ruth. Good morning, good afternoon, Mr. Ruth.
Good to see you, Judge.
Good to see you as well. All All right, so Mr. Brown is here on an arrest warrant signed by Judge Skipper. The charge is written or electronic threats to kill or do bodily injury. It comes before the court on no bond. Mr. Ruth, is it your position your client's entitled to a bond, and what would you like me to know about release?
Yes, Judge. He has no prior criminal history. He has, he'll be staying, it looks like he's gonna be going up north to be with his mother that's up in Ohio upon his release, to seek some counseling at that point in time. But he has no prior history. His brother does live here locally to amend things with him going to some treatment. So we're asking for just a reasonable bond.
All right, state.
Your Honor, the threat is against a family member, and per defense's argument, he is going to, if the court allows, he is going to be leaving the jurisdiction. This is a second-degree felony, and state would ask for the bond schedule, which is the $7,500.
All right, any other conditions, state?
No contact, and no weapons or firearms.
All right. All right, I'm gonna, having found probable cause based upon the warrant, I'm gonna set bond in the amount of 5,000. I'm gonna require that the defendant may leave the jurisdiction. Mr. Brown, you've got a really good lawyer here, but that lawyer can only help you if you keep in contact with him. I don't want it to be misunderstood by permitting you to go back to Ohio. Don't forget about us. Don't leave this behind you.
Your Honor, I want
You-
to deal with this.
All right, Mr. Brown, I know I invited you to respond to me, but your lawyer is gonna get real nervous if you say anything about the case or your intentions, because we're being recorded and we have a prosecutor here. I just want you to understand that your lawyer's gonna be here. Keep in contact with your lawyer, make sure your lawyer understands what you're going through and where you're at, so he can represent that to the court, and you may have to come back to address this case. In addition to setting the $5,000 bond on the second-degree felony, I am gonna require that you have no victim contact, that you maintain a separate residence from the victim. If you were residing with the victim at the time this occurred, you're permitted to return one time in the presence of law enforcement to collect personal effects only. No alcohol, no drugs without prescription, no weapons, no firearms. Mr. Ruth, anything else?
No, Judge, thank you.
All right, good to see you as well. Good luck, Mr. Brown. Crantis Roberto. All right, Mr. Roberto is here on a charge of petty theft from the Wawa at 6900 South OBT. Is this resolvable today, or do I need to establish conditions of release?
Conditions of release, Your Honor.
Okay. All right, I'm going to stay the bond. I'm going to find probable cause based upon the charging affidavit. Stay the bond at $500. Appoint the Office of the Public Defender. Conditions of release are no return to the Wawa located at 6900 South OBT, and no contact with any of the individuals that work there. No alcohol, no drugs without prescription, no weapons, no firearms. All right, good luck, Mr. Roberto.
Thank you. So what's
Is Ms. Hassan pleadable today?
Yes, Judge, she's gonna plea.
Okay. All right, so I have before the court today 2 violations of municipal ordinance 402, 2025 MO 402953 and 954. The charges are remaining in parks after closing hours and prohibited camping. They're both violations of municipal ordinance. I understand that Ms. Hassan wants to resolve these cases by entering pleas of no contest. Is that correct?
Yes, Judge, the offer status of both violations.
How many days does she have in?
2, Your Honor.
All right, is she ready?
She's signing the plea form right
Okay. I just can't see over the podium. All right, Ms. Hassan, I understand you want to resolve both of these violations of municipal ordinance by entering pleas of no contest. Is that what you want to do? Okay, I'll explain it to you. I'll explain it to you. So the state has the presumption, or they have the burden to prove your guilt on these things. You can enter pleas of guilty, which means, Judge, I did what they said I did, or no contest, which means, Judge, I'm not admitting that I camped or that I stayed in a park overnight after closing, but I feel it's in my best interest not to contest the charge. That's why it's called a best interest plea or no contest plea. You're going to, in effect, give up your right to have a trial. If you want to do that, I'll accept those pleas. I'll sentence you to the 2 days in the Orange County Jail you've already served, impose court costs, and send you on your way. Is that what you want to do? You don't understand?
Said I have the right to plead guilty.
Would you feel better pleading guilty?
I thought so.
Okay. All right, so do you want to enter pleas of guilty to both these charges?
What is both of the charges?
One is camping. Apparently you were camping where you can't camp. And the other is remaining in a park after closing. It's a violation of city ordinance to do those. Okay, all right. Ms. Hassan, I've been handed a plea form that sets forth all the rights that you're giving up, and you've had the assistance of an assistant public defender. Do you understand all those rights?
What do you mean all the rights that I'm given?
The rights that you have that I mentioned a moment ago is that you have a right to have a trial. If you wanted to plead not guilty, we could schedule you for a trial. We can impanel a jury. The city would have to bring witnesses to prove your guilt. You'd have an opportunity to hear that evidence, call your own witnesses, put on your own evidence or put on no evidence, and have a jury decide if you're guilty or not. At that trial, which is going to not occur today, it may be weeks or months from now, the judge would then have the ability to sentence you. If I'm happy to set bond for you, but if you can't make bond, you may have to sit in jail until that trial occurs. So do you understand that?
I said I understand that.
Okay, all right.
I understand all of what you said at first, but I understood the end.
Okay, good. Has anyone pressured you or forced you against your will to enter these pleas? Are you under the influence of alcohol or drugs today? All right. All right, Ms. Hassan, I'm going to accept your pleas of no contest or guilty to the charges of violation of municipal ordinance in both these cases. I'm going to withhold conviction of guilt on both of these, so it will not appear in your record as a conviction. I'm going to credit you the 2 days you've already served in jail on each of these. So you're going to be released today as to both these charges. There's mandatory court costs of $223 on each. I'm going to give you up to a year to pay that off. You can appeal the sentence that I've just imposed if you think it's illegal. If you want to appeal, that appeal has to be in writing, filed within 30 days, and I can appoint a lawyer to represent you for that appeal if you can't afford one. I wish you good luck.
Judge, we're going to waive reading on this next case.
All right, is this Mr. Finley? All right, Mr. Finley's here on five charges. It comes before the court on no bond pursuant to a warrant. State, is the defendant entitled to bond on these charges?
No, Your Honor.
Okay.
As probable cause has been found, state is requesting that defendant be held no bond on all 5 charges pursuant to 907.0415D.
All right. Does that, is it state's position that Mr. Finley is just not entitled to a bond, or are you requesting that there be a pretrial detention hearing scheduled?
Your Honor, as this is one of the enumerated offenses, it should be held pursuant to 907.041, and so yes, he would be entitled to a hearing unless the court is willing to hold him pursuant to Arthur. where you would have to find proof evident, presumption great, and that being the case, then he would not be entitled to a hearing.
All right. Defense?
Your Honor, if the state's asking to hold Mr. Finley no bond, we would ask for a pretrial detention hearing and for the state to file a written motion to that effect.
All right. I do not have facts sufficient to find presumption. Can I remember that? Facts evident, presumption great? Proof evident, presumption great. For some reason, that won't stay in my head. So what I'm gonna do is, I'm gonna appoint the Office of Public Defender. I am gonna hold the defendant, no bond. I am gonna find that Mr. Finley's entitled to pre-trial detention hearing, which will be conducted on all right. All right, good luck, Mr. Finley. Is this Mr. Metz?
We'll waive reading here as well, Judge.
All right. All right, Mr. Metz is on, is before the court on, appears to be 7 offenses. Nope, 12 offenses. All or no bond. State, is Mr. Metz entitled to a bond?
It's easier for me to say which ones he's not entitled to a bond on, Your Honor, and that
Alrighty.
would be counts 1 and 3. He is entitled to a bond on the remainder, those being F2s.
All right. All right, what I'm gonna do is I am going to stay the bond at none on count 1, set bond in the amount of 7,500 on count 2, no bond stayed on count 3, and then 7,500 on each remaining count. And we'll have to do the math on that. And I'm gonna set a pretrial detention hearing on
November 18th, 9 a.m., courtroom 7B, division 18.
All right, so, Madam Clerk, by my rough math, since I'm setting 7,500 on each other charge, that's 10, that'd be 75,000 total. That would be also conditions of no contact with the victim, witnesses, or any person under the age of 18. No alcohol, no drugs, no weapons, no firearms. Yeah, let me do those conditions under the one as well. And I have found probable cause pursuant to the warrant signed by Judge Barber. And Mr. Metz has requested the appointment of a lawyer, but apparently, hang on one second. All right. Mr. Metz, you have 2 dependents, is that right? Okay, and this 30,000 is what you make annually?
That's roughly what I'm guessing that I'm gonna make within the realm. I haven't had my company for more than 2 months, so it's just kind of off its feet. I've
Okay.
made probably 1,200.
Okay. Mr. Metz, did you want me to consider appointing the public defender to represent you? All right. It's a close call. I'm going to find that you do qualify based upon the fluctuation of your employment, being self-employed. I'm going to appoint the Office of the Public Defender to represent you on these charges. State, is there anything else?
No, Your Honor.
Defense. All right. Good luck, Mr. Metz. Joshua Misitich?
Set it, yes, sir.
Misitich. That makes sense, doesn't it? All right. If you look at it, it's Misitich. All right, Mr. Misitich is charged with petty theft. I've reviewed the charging affidavit. I find probable cause. I'm going to appoint the public defender's office to represent him. Stay the bond at 2,500. It's charges a felony with priors. Special conditions are no return to the Wawa located at 1090 South Clark in Ocoee. I think that should do it. Good luck, sir.
Sir.
All right, is this Ms. Roll? All right, good afternoon, Ms. Roll. Ms. Roll is charged with conspiracy to use investment proceeds from racketeering, and unlawful use of a two-way communication device. This comes in pursuant to an arrest warrant. State this bond on count one is $100,000. Welcome. All right. All right. And I've appointed the Office of the Public Defender. Anything that you want me to know regarding Ms. Roll's conditions of release?
Conditions of release, no, Judge, just based on the face sheet, it seems like she's been relying on Social Security income for a number. Understanding the severity of the offenses, I think the bonds being as high as they are, I don't know Ms. Roll's capacity to actually get released with the bond.
Okay. Well, this is the initial appearance, and so I'm going to stay the bonds based upon the representation from the state and the recommendation from the state and the warrant that was signed. The probable cause is from the warrant. Certainly, this matter can be brought before the judge in Division 17 upon motion to modify or reduce bond. I'm also going to impose the condition of no contact with co-defendants or victims. If Ms. Rule has a passport upon release within 24 hours, she's to surrender that passport. No weapons, no firearms. Anything else, State? All right, anything else, defense? I'm sorry?
The amount again, please.
It's $100,000 on count one, which is the conspiracy, and $1,000 on the unlawful use of a two-way communication device. Is that all you have? You may. Wesley Session?
Correct. I plead not guilty.
All right.
I will take this case to trial.
Okay,
I will include Orange County Sheriff's Office,
Okay.
Orlando Police Department,
All right.
EOC, and
Okay.
Aspire Health in this case.
all right, thank you, Mr. Session. Are we going to proceed without Mr. Session?
We'll wait for
Waive his appearance, all right. All right, so I've reviewed the charging affidavit. Mr. Session is charged with disturbing a school assembly, burglary to an occupied structure, trespass on school grounds, criminal mischief, and false fire alarm. All charges except the burglary to an occupied structure come into the court with bonds that are relatively reasonable. The burglary to an occupied structure, is that an F2?
I believe it's an F3, Your Honor, but one moment.
Mr. Session has asked that I appoint the public defender. He qualifies, I'm going to appoint the Office of the Public Defender. I'm going to find probable cause based on the charging affidavit. I'm going to stay the bonds in counts 1, 3,
That is an F2, Your Honor.
and F2. All right. All right, I'm gonna set bond on the burglary charge in the amount of $5,000. Stay the bonds on counts 1, 3, 4, and 5. By my rough math, that should be $5,000, $6,250. No return to the Meadowbrook Middle School, located at 6,000 North Lane. No contact with any of the witnesses or victims of that. No alcohol, no drugs without prescription, no weapons, no firearms. All right, now it looks like we've got an arraignment on Ms. Baker.
Your Honor,
look how they have me chained up. I never murder anybody or do anything. I was just asking to be released to go back to my family. I'm about to lose it. And
Okay. All right, Ms. Baker, let's talk about that in a minute, all right? I'll give you just a moment. I've got Ms. Baker here, a Division 83 case. She's charged with leaving the scene of an accident without giving information. She's been in custody for 16 days. Is it my understanding this is set for arraignment today?
Yes, Your Honor.
It is separate.
No, you did not. There were no offers on any of the arraignments.
Okay. The public defender is representing Ms. Baker. Did you want to enter a plea of not guilty on her behalf?
Yes, Judge.
All right, and then this is going to be set for a pretrial conference on
December 18th, 8:30 a.m., Division 8.
All right. She's got 16 days in. What is her current bond? Does she have a bond?
She has a total bond of 10,000. She has another case as well.
Another case as well?
Yes, 10,000 total.
All right. All right, so enter plea of not guilty, set this for pretrial conference in Division 83 on December 18th, and I will entertain any motions between now and then. Is the other charge also in Division 83?
No, it's a felony.
Felony, okay, all right. All right, good luck, Ms. Baker. Oh, we've also got a reckless driving. I think that's what you were trying to tell me. We're going to enter plea of not guilty on that charge as well.
The same date of December 18th, 8:30 a.m., Courtroom 9B, Division 80.
All right, so one is 041 and one is 040. Got it. Thank you. Is this Brian Gilman? All right, Mr. Gilman's here on a charge of petty theft. He's got 17 days in on that charge. He is not currently represented. State, there's no offer on this?
No offer, Your Honor.
Did you want to be, Mr. Gilman, did you want to resolve this today, or did you want me to consider appointing a lawyer to represent you? Tell me your thoughts.
Well, I have some felonies, and if I resolve it today, would it go against my felonies?
You know, if you're also being held on felonies, you're not going to get out today because I'm not going to take a plea on felonies. So what I'm going to do is I'm going to enter a plea of not guilty on this charge. This may be the lesser of the charges that you're facing. Did you want me to consider appointing a lawyer to represent you? Did you want to represent yourself or hire a lawyer?
I already have two right now, so.
Okay, do you have public defenders on the felonies?
Yes.
All right. All right, based upon that representation, I'm going to appoint the public defender to represent you on this in misdemeanor division 83. Appointing the office of the public defender, entering a plea of not guilty, and setting it for pretrial conference on that December 18th date at 8:30 in courtroom 9B. All right, good luck, sir.
Do I have a bond on this?
That's a great question. Okay. I don't know the answer to that.
Okay.
All right. Antonio Parkinson,
And he did have a bond on that
you
case.
did have a bond?
He does. He have a bond of 1,000 on that. He's in on multiple
Felonies?
cases.
Yeah, he's got other bigger problems. All right, Antonio Parkinson is here for arraignment. He's charged with violation of a domestic violence injunction. He's represented by the Office of the Public Defender. He's got 124 days in. Looks like 85 plus 39 on VOPs. Did you want to enter a plea of not guilty on his behalf and set this for pretrial conference in front of Judge Allen in Division 50?
Yes.
VOP status, I'm sorry, that makes perfect sense, doesn't it? All right, I'm going to enter a plea of not guilty on behalf of Mr. Parkinson. He's represented by the Office of the Public Defender. That'll be set for VOP status in Division 50 on.
That'll be December 8th, 1:30 p.m., Courtroom 4A.
All right, good luck, Mr. Parkinson. All right, next I've got Carmelo Aponte.
And he does qualify for PTR, Your Honor.
Okay. All right, Mr. Aponte is here on a charge of trespass at the Orlando Health. How many days does Mr. Aponte have in?
It's 2, Your Honor.
All right. Is this pleable?
An offer was relayed, Your Honor.
I'm sorry, I didn't hear you.
An offer was relayed. It is a withhold and credit time served, no return to 17,000 Porter Road.
All right, Mr. Aponte, I understand you want to resolve this charge today, which is trespass, by entering a plea of no contest in return for my sentencing you to the time that you've already served and releasing you today. Is that what you want to do?
Yes.
I've been handed a plea form. It's written in English. It has your signature on it. It also has the signature of the Assistant Public Defender who stands to your left. That tells me that you've had an opportunity to review this and have had your questions answered before you signed it. Is that right?
That is correct.
All right. Has anyone pressured you or forced you against your will to enter this plea?
No,
Are you under the influence of alcohol or drugs today?
no, I'm not.
You understand if you're not a U.S. citizen, you can be deported, right?
Yeah, I'm a
All right.
citizen.
All right. All right, Mr. Aponte, I'm going to accept your plea. I'm going to withhold adjudication of guilt. I'm going to sentence you to 2 days in the Orange County Jail with credit for the 2 days you've already served, which means that you're done with your jail sentence today, which means you'll be released. I'm also going to require you not return to the Orlando Health Horizon West at 17,000 Porter Road within Orange County. There's also mandatory court costs, which should run you $273. I'll give you up to a year to pay that off. I'm going to waive the public defender fee because I haven't appointed the public defender. You just got some free advice from the assistant public defender, so you can thank him for that. Sir, I've accepted your plea and imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, that appeal must be in writing, filed within 30 days, and if you can't afford an attorney for that appeal, I can appoint one. I wish you good luck, sir.
Thank you so much.
You're very welcome, sir. All right, John Benitez. All right, Mr. Benitez is here on a charge of battery. I've reviewed the charging affidavit. I find probable cause on the charge of battery. I'm going to stay the bond at $1,500. I'm going to appoint the Office of the Public Defender to represent Mr. Benitez. Upon his release, he's to not return to the location of this offense, which appears to be 1913 North Orange Avenue, which is, I just saw this here, the Savoy Orlando Bar. No good comes of you going back there. No contact with the victim. Ms. Yakalan. No alcohol, no drugs without prescription, no weapons, no firearms. And if I've not already said it, I'm appointing the public defender to represent Mr. Benitez. Good luck, Mr. Benitez. Kenneth Clay. Mr. Clay is charged with trespass and resisting an officer without violence. Mr. Clay, interested in resolving these cases today?
Yes, Your Honor, he'll be playing the offers adjudication guilt, credit time served, no return to the scene of the incident, which was the Spats Bar at 1025 Fairbanks Avenue, Winter Park, Florida.
Driven by that place, never gone in. Okay. How many days does Mr. Clay have in?
It's 1 day, Your Honor.
Okay. All right, so Mr. Clay, I've been handed a plea form. It's written in English. It has your signature on it as well as that of the lawyer that stands to your left. That signature tells me you had a chance to review this before you signed it and you had all your questions answered. Is that right?
Yes, sir.
Has anyone pressured you or forced you against your will to enter these pleas?
No, sir.
Are you under the influence of alcohol or drugs today?
No, sir.
All right, you understand that if you're not a U.S. citizen, you could be deported by entering this plea? Sure. You understand that if you're not a U.S. citizen, you could be deported by entering this plea?
Yes, sir.
All right. All right, Mr. Clay, I'm going to accept your plea. I'm going to adjudicate you guilty on both the charge of trespass and resisting an officer without violence. I'm going to adjudicate you on both of those. I'm going to credit you the 1 day that you've served on both. I'm going to require that you not return to the Spats Bar, which is located at 1025 Fairbanks Avenue, Winter Park, Florida. And I'm gonna impose mandatory court costs, which should run you $273. I'll give you up to a year to pay that off. I'm gonna waive the public defender fee, so you got some free service from a very good lawyer. So he can be rewarded with your thanks. All right, sir, I've accepted your plea. I've imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, that appeal must be in writing within 30 days, and I can appoint a lawyer. All right, good luck, sir. All right, John Hedridge.
He refused his appearance, Your Honor.
All right, should we waive his appearance and conduct initial appearance?
Yes, Judge.
All right, we'll waive Mr. Hedridge's appearance today. I find probable cause for the charge of petty theft from the Walmart. I'm going to stay the bond at 500, appoint the Office of Public Defender, in order that upon release, he's not to return to the Walmart located at 5734 South Orange Blossom Trail. No alcohol, no drugs, no weapons, no firearms. Next, I have Angela Hillian.
She refused her appearance, Your Honor.
All right, should we waive her appearance and proceed with the initial appearance?
Yes, Judge. In this case, we're requesting Ms. Hillian be R-ward. She is currently in competency proceedings in another case. I can get you a case number on that.
All right, so she's previously been declared to be incompetent?
So far as I can tell, I don't think she's been previously declared to be incompetent. She's got an evaluation scheduled in our office. Evaluation was scheduled prior to her obviously getting arrested on this new city ordinance case.
No.
I believe the FTA was for a failure to appear in that case where the competency proceedings are currently ongoing.
All right, and do we know when that evaluation with Dr. Arias is going to be at your office?
Yeah, I can try to pull it up right now real quick, Judge. So the evaluation was scheduled for October 28th, but she had KPS and then no-showed the evaluation. So I don't think we rescheduled. I think we were waiting until we got her again, scheduling the evaluation just because we lost contact.
All right, my concern with granting your motion to ROR her on this is you're not gonna know how to find her. She's gonna be at large until she gets picked up.
The other concern is then she's kind of held in OCJ for another probably 2 months, given the backlog of scheduling evaluations. I mean, if we're able to ROR her today, we can have people in our office try to talk to her in BRC this afternoon and get some better contact, more recent contact information.
Your Honor, the state would object. As is right now, the defendant has not been found incompetent to proceed. She has an FTA out there, and I doubt that there's been no testimony that the PD's office has been able to keep in contact with her, or that she's been able to keep in contact with the PD's office, so that if she is ROR'd, she will be able to follow up with any date. So as is right now, state would object, and she should be put on bond.
Yeah, it looks like but for her being arrested on the public urination charge, she'd still be at large under the KPS. Who's the judge in Division 61?
Stop.
Okay. All right, I'm not going to disturb Judge Starr's KPS. She has a reason why she's set bond in the amount of $1,000. So I'm going to stay the bond. Should she post bond, I'm going to require as a condition of her release that she keep in contact with her lawyer and attend any and all court appearances as well as evaluations, competency evaluations on the new charge of public urination in violation of a municipal ordinance. I'm going to stay the bond at $250. I'm going to appoint the public defender on that charge. Only condition is that she remain in contact with her lawyer and comply with all orders of the court. All right, next I have June Howell Jambor.
She's on mental health status, Your Honor.
All right, so that means that we don't know when she's going to be available, or she's still in the jail?
She's still here.
Okay. Did you want to waive her appearance?
Judge, And in this case, Ms. Howell-Jambor was found incompetent by Judge Jewett back in April, and I can give you a case number for that.
Okay. So this is a new law violation after her finding of incompetence?
Correct. She was found incompetent April 22nd by Judge Jewett. Placed on conditional release at that time.
You know what the terms of that conditional release are?
I can pull it up real quick. Reside in Orange County, receive mental health treatment as needed, receive competency restoration through Aspire. Defendant will not drink alcohol or use illegal substances and will not possess any firearms or other weapons.
And what was the charge in that case?
Trespass.
State, so, in the case that's assigned to Judge Jewett, apparently she's already been found to be incompetent on conditional release, picked up a new trespass charge. The bond on the charging affidavit for Ms. Howell-Jambor, who identifies on her paperwork as being unhoused, that bond is $500. What's the state's position on releasing her, staying the bond, conditions of release?
Yeah, I can get you the case number for the other misdemeanor case if you need.
Your Honor, as the defendant has been found incompetent to proceed, state would have no objection to an ROR, Your Honor.
All right, I think that's probably the best way to proceed. All right, defense motion without objection. I'll go ahead and release Ms. Howell-Jambor on her own recognizance. I'll appoint the public defender on the new law violation. I will impose a release which will include no return to the Circle K located at 1607 South Cimarron Boulevard in Orlando, Florida. No alcohol, no drugs, no weapons, no firearms. Keep in contact with her lawyer that I've just appointed and attend all court appearances. State, anything else?
No, Your Honor, thank you.
Defense?
Nothing further, Judge.
All right, thank you. Is this Melissa Lemasters?
Yes, sir.
All right. All right, Ms. Lemasters is here on a charge of violation of condition of pretrial release. Did I see this case earlier? Charging affidavit looks familiar to me, either from reading it earlier or from before. Looks like she was out. What was the original charge?
The face sheet says harassment.
Harassment, Your Honor.
Harass. All right. Oh, this big orange thing that's right in my face that I had to turn over? All right, I apologize. All right, well, State, what's your thought? This comes in as a no bond. Apparently, Ms. Lemasters was able to post bond in the amount of $150 November 4th, and now she's back.
Your Honor, it is the same victim. And as this is ongoing, state would ask that you revoke the out on bond and double that. She is entitled to a bond on the new law, Your Honor.
The violation of pretrial release conditions, is that a first-degree misdemeanor?
Yes, Your Honor.
I'm just concerned in setting bond and conditions of release that Ms. McMasters, it's going to sound like, Ms. LeMasters, it's going to sound like I'm inviting you to respond to my thoughts. I'm going to caution you, and I know how that sounds. Well, the judge is inviting me to explain myself. This is a criminal charge. It's a new criminal charge. You've got an old criminal charge. We're being recorded. We've got a prosecutor here. I'm going to, you're asking that I appoint a lawyer to represent you. Your lawyer's going to get really nervous if you start talking about the facts of this case. So I'm going to, it's up to you, but I'm going to recommend that you not say anything. And if you want to say something, save your words until I'm done with this. And if you want, when I'm done with this, you can hear what I'm saying. You might want to whisper in Mr. Campbell's ear, and he might be able to answer your questions for you. What I'm going to do is I'm going to set bond in the amount of $1,000 on the new law violation, which is violation of conditions of pretrial release, based upon the charging affidavit that I've reviewed, the four corners of which establish probable cause. I am going to appoint the public defender's office to represent Ms. LeMasters. I'm going to revoke her existing bond, which they tell me is $150, which seems like not much at all. And I'm going to impose a new bond in the amount of $500. So that's going to be $1,500 total on the old case and the new case. Conditions are no contact, directly or indirectly, with any victim or witness in the original harassment charge. I don't know if I can be any clearer than that. The paperwork that I've recently reviewed that I sign spells out exactly what that means. No electronic communication in person through third parties. No good is going to come from any of that. No alcohol, no drugs, no weapons, no firearms. This appears to be an electronic communication, so especially none of that. Ms. LeMasters, the only thing that I can tell you is that if you return to appear before me with the original charge, a violation of the pretrial release conditions, and then another charge related to this, I have no doubt that the state will be very persuasive in arguing that there are no conditions that can ensure that you will not violate the law while you're out, and you may have to sit in jail until these cases are over. Why don't you whisper to your lawyer any questions that you've got before you voice those on the record in public before the prosecutor.
It's 15.
All right, good luck. All right, next I have Quentin Richmond. All right, Mr. Richmond's here on a charge of loitering or prowling. I've reviewed the charging affidavit. I find probable cause. The bond seems a little low on this, but I state any objection to my staying the bond at $250?
No objection, Your Honor.
Right.
The defendant is on probation.
Ooh, all right. Well, then that's not going to last long. All right. I'm going to stay the bond at $250. I'm going to require the defendant not return to the location of this offense, which appears to be 1648 Holden Avenue, Orlando, Florida. I'm going to require the defendant also have no contact with any witnesses or victims. No alcohol, no drugs, no weapons, no firearms. Mr. Richmond has requested I appoint the public defender. However, it appears that he does not qualify. Let me just check with the clerk. Mr. Richmond, you have no dependents, and this is how much you make every week? All right.
Said he's not sure if he still has that job.
Where do you work, Mr. Richmond?
What is that?
It's a distribution warehouse for Little Caesars.
All right, well, based upon the income that you currently earn, I'm going to find you don't qualify for the appointment of a lawyer. You're going to see the judge in Division 80, and you can always readdress that with the judge. If you get out of jail and you got your job back, you can go into the marketplace and hire a lawyer or represent yourself. If you find yourself unemployed, you can certainly fill out an affidavit, a new affidavit with the new judge, with the judge that's assigned to the case, and he or she will entertain a motion to appoint. All right, good luck, sir. Roger Roberts.
He does qualify for PTR, Your Honor.
All right, thank you. All right, Mr. Roberts is here on charge of petty theft from the Home Depot. I find probable cause. Mr. Roberts is asking that I appoint the public defender. He qualifies. I'm going to appoint the public defender. I'm going to release him on pretrial release, unless he would rather post the $250 monetary bond. Mr. Roberts, would you rather deposit money or be on pretrial release that doesn't require any money but requires you to follow the rules?
I don't understand, sir.
All right. Mr. Campbell, can you whisper in his ear what the choices are?
Pretrial release.
All right, I'm going to release you on pretrial release. I'm going to require you not return to the Home Depot located at 7022 West Colonial Drive. No contact with any witnesses or victims. Looks like there is a reporter of the crime from Home Depot. No alcohol, no drugs, no weapons, no firearms, and I've already appointed the public defender. Mr. Roberts, good luck.
Thank you.
You're welcome. All right, is this Stanley Simpson?
Yes, sir.
All right, so Mr. Simpson is a returning champion. Looks like his new charge is possession of drug paraphernalia. I've reviewed the charging affidavit. Find probable cause on that. I'm going to stay the bond at 500. Mr. Simpson wants me to appoint the public defender, which I'll do. He qualifies. He's already out on bond on possession of cocaine and possession of drug paraphernalia from the 15th day of September, and possession of drug paraphernalia and possession of a controlled substance, for which he served 33 days and got out about 2 weeks ago. State your thoughts on those out on bonds.
Your Honor, as it has been slightly more than 2 months, and this is the third drug-related offense, State would ask that you revoke the out on bonds, or if it's ROR, to revoke the ROR and either double the bond that is existing or set a new bond.
All right, on 2025 CF 12576AO, the charges, this is Division 20 case. The defendant's out on charge of possession of paraphernalia and a controlled substance. He was released on October 28th. It appears as though he was ROR'd. I'm going to revoke that release on his own recognizance, set new bond in the amount of $1,000 on the paraphernalia and $2,500 on the possession of controlled substance. On 2025 CF 11410AO, the charge of possession of cocaine, possession of drug paraphernalia. I'm going to revoke the release on those charges. I'm going to double the previous bonds, so the new bond for the possession of cocaine is going to be $5,000, and on the possession of paraphernalia would be $2,000. So he's going to have 5 and 2, and 25 and 1, and 500. Did you get all that? Okay. If you look at the old one, I doubled that. And the original one is what I put on the one that was ROR, and then I stayed the other bond. All right? All right, and I've appointed the public defender to represent Mr. Simpson. Good luck, Mr. Simpson. Mr. Simpson, why don't you whisper in your lawyer's ear what you want me to know? And then if he says it's okay, he'll either communicate that with me or let you ask me.
Can I say something?
I don't recommend it, but you can tell me what you want me to know.
I just want to know if I can, resume this case.
Your Honor, he was asking for a bench offer.
No. You've got too many, you've got open cases, you've got a new case. I don't think that's appropriate. Are they in different divisions at this point?
No, Your Honor, they're both in Division 20.
Okay. You certainly can talk to the judge in Division 20. Good luck, sir. All right, Sana Vitter.
She's on mental health status, Your Honor.
All right, do you want to waive her appearance on the resisting arrest?
Could we reset it to tomorrow, Judge?
Sure. I'm gonna be here.
There's an offer if she's.
Gotcha. Figured you had a reason. What about Jamal Wilson?
Scene. Time right there.
How many days does Mr. Wilson have in?
He's 2, Your Honor.
All right.
This time, Mr. Wilson's going to enter a plea of no contest to the time served and no return to the scene of the alleged trespass.
Okay. It's just the happiest place on earth. Nobody wants to leave it. All right, so Mr. Wilson, your lawyer tells me you want to resolve this case today by entering a plea of no contest to the charge of trespass. Is that what you want to do? All right.
Your Honor,
Yes, ma'am.
I did not make an offer on Jamal Wilson.
Oh,
Well, State, how do you feel about a 2-day credit for time served with an adjudication for refusing to leave Walt Disney World?
Your Honor, I didn't make an offer because on the face sheet, it indicates that that there may have been some mental health issues. That is why I did not. It was last year, but that is why I did not make an offer at this time.
Sure. Come on up. It's Jamal Malik, that's why. All right, let's go ahead and, we'll just go ahead and fix that, and we can have him stand behind the other gentleman, or you need all the attention to pay attention to that, so if you want to, I can wait a minute. If it's getting this case resolved for the judge in Division 84, I'm all for it.
We can address Mr. Wright first, Judge.
Okay. All right, we're going to pass Mr. Jamal Malik Wilson just for a moment. He's just going to step back, and Mr. Wright's going to step forward.
This is Daniel Wright, Judge.
Daniel Wright, 2025 MM 409191, charged with the offense of trespass. Does Mr. Wright want to resolve this case today by entering a plea of no contest?
Yes, Your Honor.
All right, how many days does Mr. Wright have in?
2, Your Honor.
All right. All right, Mr. Wright, I've been handed a plea form. It's written in English. It has your signature on it. Also has a signature of the lawyer that stands to your left. That tells me you had a chance to review this, and maybe the lawyer was able to answer all your questions. Is that right? All right. Has anyone pressured you or forced you into entering this plea? Are you under the influence of alcohol or drugs today? You understand if you're not a U.S. citizen, entry of this plea could result in your being deported from the United States, right? All right, Mr. Wright, I'm going to accept your plea of no contest to the charge of trespass. I'm going to withhold conviction of guilt so it will not appear on your record as a conviction. I'm going to sentence you to the 2 days in jail you've already served. So you're going to be released today as to this charge and discharge alone. I'm also going to require you not return to the Crystal located at 6201 West Colonial Drive. You're now going to become a White Castle customer. Court costs are going to run you $273. I'll give you up to a year to pay that off. Your assistant public defender has helped you, but I haven't appointed him, so I'm not going to charge you a fee for his services. Sir, you've entered a plea and I've imposed a sentence. If you think my sentence is illegal, you can appeal me in writing in 30 days, and I can appoint a lawyer for that appeal if you can't afford one. Good luck. We can take another run at Mr. Jamal Malik Wilson.
Yes, Your Honor.
All right.
So, Mr. Wilson would like to enter a plea of no contest to the trespass charge with the agreement being an adjudication of guilt. I'm certain no offense to the alleged trespass.
All right. Adjudication. This pile hasn't gotten any shorter. It seems like I'm flying. All right, so Mr. Wilson, I've been handed a plea form. It's written in English. It has your signature on it. It also has a signature of the lawyer who stands to your left. I understand that you were able to talk to that lawyer. He was able to help you understand the rights that you're giving up by entering this plea. Is that right? Has anyone pressured you or forced you against your will to enter this plea? Are you under the influence of alcohol or drugs?
Sir.
You understand if you're not a U.S. citizen, you could be deported by entering this plea, right? All right. All right, Mr. Wilson, I'm going to accept your plea of no contest to the charge of trespass from the Walt Disney World. I'm going to adjudicate you to be guilty of that offense. I'm going to sentence you to the 2 days you've already served in jail. So you'll be released today as to this charge and this charge alone. I'm required that you not return to the Walt Disney World property located at 1780 Seven Seas Drive. Court costs are mandatory in the amount of $273. I'll give you up to a year to pay that off. And I'm going to not impose a public defender fee because I've not appointed a lawyer to represent you. You got some free advice. Sir, you've entered a plea. I've imposed a sentence. If you think my sentence is illegal, you can appeal me. Any appeal must be in writing, filed within 30 days, and I can appoint a lawyer for that appeal. If you can't afford one, sir, I wish you good luck. All right, next I have Alicia Garcia. All right, Ms. Garcia is here on a failure to appear for a pretrial conference.
Like I said earlier.
In Division 84. That judge asked me to set the bond. That judge set the bond in the amount of 0. Does Ms. Garcia want to resolve this today?
Yes, Your Honor.
All right.
The agreement with the state is a withhold adjudication of guilt, credit time served, no return to the alleged mapping, as well as SCD testing.
Does she have public defender previously appointed?
Yes.
All right. How many days does Ms. Garcia have in?
It's an FTA, so I don't know, Your Honor.
Okay.
So she had original days.
Okay. All right. I know you will. So she missed court. Arrested yesterday. She missed court in October. All right. So Ms. Garcia, your lawyer tells me you want to resolve this case today by entering a plea of no contest to the charge of prostitution. Is that what you want to do?
Yes.
Okay. I've been handed a plea form. It's written in English. It has your signature on it as well as the signature of your lawyer. Did you have a chance to go over the plea form with your lawyer, and was he able to answer all your questions about all these rights that you're waiving?
Yes.
All right. Has anyone pressured you or forced you against your will to enter this plea? No. Are you under the influence of alcohol or drugs today? You understand that if you're not a U.S. citizen, entry of this plea could result in you being deported from the United States. All right. I'm going to accept your plea of no contest. I'm going to withhold adjudication of guilt. I'm going to sentence you to the number of days you've already served in jail. So you'll be released today as to this charge. I'm going to require you not return to the mapping zone, which is a marked off area where you can't return. You're also to undergo sexually transmitted disease testing with proof that you've had the testing done, not necessarily with the result. That's going to be filed with the clerk within 90 days. I'm also going to impose mandatory court costs of $273 and $50 for the services of your lawyer. I'm going to give you up to a year to pay that off. Is there anything I've overlooked, State?
No, Your Honor.
Anything I've overlooked? Defense. All right. Ms. Garcia, you've entered a plea. I've accepted your plea, and I've imposed a sentence. If you think my sentence is illegal, you can appeal me. Any appeal must be in writing, filed within 30 days, and if you can't afford a lawyer for that appeal, I can appoint one. Since you've resolved this case today, you don't have to worry about going back to see the judge in Division 84. Good luck. No, withhold. Well, look at the odds of this. That was a Jamal Malik, and this is a Malik Joshua. Now I understand the confusion.
Judge, Mr. Wilson's going to enter a plea of no contest to the alleged trespass charge with the agreement being an adjudication of guilt, credit time served, no return to 5462 Clarkona Boulevard. Is what that said? The scene of the alleged trespass.
25. Thank you. All right, sir. I've been handed a plea form, Mr. Malik Wilson, and this sets forth all the rights that you're giving up. It also has your signature and a signature of the lawyer who stands to your left.
Yes.
That tells me that you've had a chance to review this and your lawyer's answered all your questions. Is that right? Is that right? All right. Has anyone pressured you or forced you against your will to enter this plea? All right. Are you under the influence of alcohol or drugs today?
No, sir.
And you understand if you're not a U.S. citizen, you could be deported by entering this plea?
Yes.
All right, Mr. Malik Wilson, I'm going to accept your plea. I'm going to adjudicate you to be guilty of the offense of trespass. I'm going to sentence you to the 25 days you've already served in jail, so you're going to be released today as to this charge. I'm going to require you not return to the location of this offense, which is the 5462 Claricona Key Boulevard. And I'm going to impose mandatory court costs and also costs for the services of your lawyer. That's going to total $323. I'll give you up to a year to pay that off. Sir, I've accepted your plea and imposed a sentence. If you think my sentence is illegal, you can appeal me. If you want to appeal, that appeal must be in writing, filed within 30 days. And if you cannot afford an attorney for that appeal, I can appoint one. I wish you good luck, sir. How many days does Mr. Martinez have in?
He has 2.
Judge, the offer on this case is 3 days OCJ, so he would get out tomorrow.
I'm going to do 3, and I gave him 2. So he's going to serve 1 more. All right, so Mr. Martinez, your lawyer tells me that you want to resolve this case today by entering a plea of no contest to the charge of being in the park after dark. Is that what you want to do?
Yes, sir.
All right. I've been handed a plea form. It's written in English. It has your signature on it, and also has a signature of the lawyer who stands to your left. This tells me that you had a chance to review this with a lawyer, and he answered all your questions about the rights that you're giving up. Is that correct?
Correct.
Has anyone pressured you or forced you against your will to enter this plea?
No, Your Honor.
Are you under the influence of alcohol or drugs today?
No.
You understand that if you're not a U.S. citizen, entry of this plea could result in you being deported from the United States? All right, sir, I'm going to accept your plea. I'm going to adjudicate you guilty of this violation of municipal ordinance, which is remaining in the park after closing hours. I'm going to sentence you to 3 days in the Orange County Jail. I'm going to credit you 2 days, which means you've got 1 more day, so you're going to be out early tomorrow. There are also mandatory court costs of $223. I'll give you up to a year to pay that off. I'm gonna assume there wasn't a filing and there's no public defender appointed, is that right?
Right.
All right, I'm also gonna require that you not return, to this park, which is the Kevin Tyjeski Park. Just don't go back there, no good comes of it, all right? All right, sir, you've entered a plea, I've accepted that plea and imposed a sentence. If you think my sentence is illegal, you can appeal me. Any appeal must be in writing, filed within 30 days, and I can appoint a lawyer to represent you on that appeal if you can't afford one. I wish you good luck, sir. All right, is this Mr. Shipley?
Yes.
All right, does Mr. Shipley want to resolve his improper prohibited camping? How many days does Mr. Shipley have in?
2, Your Honor.
Oh, he's got 2 cases.
2.
He's got 2 municipal ordinances. The other one is being in the park after dark. It's fun to say, I'm gonna say that from now on. It takes over a little. Thank you. All right, so Mr. Shipley, I understand you want to resolve both these cases. One is remaining in the park after dark. The other one is prohibited camping in violation of municipal ordinances, 2025 MO 402957 and 956. I've been handed a plea form, written in English, has your signature and that of your lawyer. Your lawyer answered all your questions about these rights, correct? Has anyone pressured you or forced you into entering these pleas?
No,
Are you-
mistaken.
Okay. Okay. Are you under the influence of alcohol or drugs today?
No,
Okay. And you understand if you're not a U.S. citizen, you could be deported by entering pleas to these violations of municipal ordinances, right? All right, sir. I'm gonna accept your plea on 2025 MO 402957, remaining in the park after dark. I'm gonna withhold adjudication of guilt, sentence you to 2 days in the Orange County Jail. Court costs are mandatory in the amount of $223. I've not appointed the public defender, so I'm gonna save you $50 and not impose that fee. You're gonna have up to a year to pay that $223. On the case ending in 402956, also municipal ordinance, prohibited camping, I'm gonna accept your plea, withhold adjudication of guilt, credit you that same 2 days, and the same $223, actually another $223. So you're gonna have $446. Give you a year to pay all that. Mr. Shipley, you've entered pleas to these 2 municipal violations. I've accepted those pleas and imposed sentences. If you think my sentences are illegal, you can appeal me. If you want to appeal, your appeal must be in writing, filed within 30 days, and if you cannot afford an attorney for those appeals, I can appoint one. I wish you good luck, sir. Iram Velastrada.
a bonnet, Your Honor.
David Webster. All right, Mr. Webster is charged with public urination in violation of a municipal ordinance. Do you want to resolve this case today? How many days does Mr. Webster have in?
2.
I guess by looking at the paperwork, I could have figured that out since he was arrested yesterday and today is today. It's just good to know. Thank you. All right, Mr. Webster, I understand you want to resolve this public urination case by entering a plea of no contest. This is a violation of a municipal ordinance. Is that what you want to do?
Yes, sir.
Been handed a plea form, written in English, has your signature, signature of your lawyer. It tells me you've had a chance to review this with your lawyer and he's answered all your questions, right? Has anyone pressured you or forced you against your will to enter this plea? Are you under the influence of alcohol or drugs today? Are you under the influence of alcohol or drugs today? You understand if you're not a U.S. citizen, you can be deported by entering this plea, right? All right. All right, sir, I'm going to accept your plea. I'm going to adjudicate you guilty. I'm going to sentence you to 3 days in the Orange County Jail with credit for 2 days, which means you're going to get out tomorrow. I'm also going to impose mandatory court costs on this municipal ordinance, which is $223. I'm going to waive the public defender fee because I have not appointed one. You just got some free advice. Sir, I'm also going to require that you not return this isn't a trespass, so never mind. All right, sir, you've entered a plea. I've imposed a sentence. If you think my sentence is illegal, you can appeal me. Any appeal must be in writing, filed within 30 days, and if you cannot afford an attorney for that appeal, I can appoint one. Good luck, sir.
Thank you, sir.
Thank you. All right, next I have Victor Arroyo.
Bonnet, Your Honor.
I thought. Marcus Crawford. All right, Mr. Crawford is here on a charge of driving with license suspended or revoked with knowledge. I find probable cause based upon the citation and the affidavit. I'm going to stay the bond at 500. Mr. Crawford has requested that I appoint public defender. He qualifies. I'll so appoint. Mr. Crawford, the only condition of release in addition to the $500 bond, don't get caught driving again until you get a license. And you might want to work on getting your license before you come back and see me on your next court date. Good luck.
Thank you. Have a blessed day.
You're welcome. Thank you. Ronnie Hunter. All right. All right. Ms. Hunter is here on the charge of failure to appear. Bond is set in the amount of $1,000 by the judge to whom she failed to appear, before she failed to appear. That's a Division 80 case on the charge of a no valid DL. I'll stay the bond at $1,000. Only condition is don't get caught driving without a valid license. Ms. Hunter, did you want me to appoint a lawyer to represent you? Did you want to represent yourself or hire a private lawyer?
We had an offer on this case, right? Judge, we had an offer on this case. I think Ms. Hunter's going to pay out.
Okay, on the no valid?
Yeah, it's just a withhold for time served.
How many days does Ms. Hunter have in? Sure. Okay, all right. All right, Ms. Hunter, your lawyer tells me you want to resolve this case today by entering a plea of no contest. Is that what you want to do? You just speak up a little louder.
Yes.
All right. I've been handed a plea form. It's written in English. It has your signature on it. Also has the signature of the lawyer that stands to your left. That tells me you had a chance to go over this with your lawyer and he answered all your questions. Is that correct?
Yes, sir.
Has anyone pressured you or forced you against your will to enter this plea?
No, Your Honor.
Are you under the influence of alcohol or drugs today?
No, sir.
You understand that if you're not a U.S. citizen, entry of this plea could result in you being deported from the United States?
Yes, Your Honor.
All right. All right, Ms. Hunter, I'm going to accept your plea of no contest to the charge of operating a motor vehicle without a valid driver's license. I'm going to withhold conviction of guilt. I'm going to sentence you to the 2 days you've already served in jail, so you'll be released on this charge. Court costs are mandatory in the amount of $301. I'm going to give you up to a year to pay that off. And the public defender was not appointed, so I'm going to waive the public defender fee. I'm going to advise you, Ms. Hunter, that I've imposed a sentence based upon your plea. If you think my sentence is illegal, you can appeal me in writing within 30 days, and I can appoint a lawyer for that appeal if you can't afford one. Good luck. Don't get caught driving without a license again.
Thank you.
Hello, is this Mr. Monks? All right, can you hear me all right, Mr. Monks? Can you hear me now? Can you hear me now? Can you hear me now? All right. All right, Mr. Monks, if I'm too loud or too soft, let me know. You can't hear it all? How about now? Can you hear now?
Yeah.
Can you hear now? How about now? Can you hear me now? Yep, I got it right in front of
If
me.
I had a court date, I would have went, sir. You want-
Okay. All right, so Mr. Monks, you are here on a failure to appear. There was a warrant issued for your arrest. The bond was set in the amount of $2,500. This is with Judge Starr.
I never had a court date, Your Honor.
Okay. As a private attorney? Mr. Monks, do you have a private attorney? Have you retained an attorney? Do you have an attorney?
Yes, I have two. I have one attorney and they changed it. They
Okay.
changed the attorney, and I
Okay.
never had a court date. I kept
Okay.
calling bail bondsman every week.
Okay.
And I'm not supposed to be here.
Okay. All right, well, I'm going to stay the bond at $2,500. I'm not going to appoint the public defender because it looks like you already have an attorney. And you can go back and see Judge Starr in Division 61 about resolving the charge. Good luck, sir.
If I could speak.
Nope, nobody does. Is Donovan Moreland here, or did he bond out? Yeah, I thought. All right, good deal. How about John David Senquiz? Making me happy. How about Cindy Bosquet? All right, Mr. Bosquet's here in charge of possession of fentanyl. I've reviewed the charging affidavit. I find probable cause. I'm going to appoint the public defender to represent him. I'm going to stay the bond at $2,500. Special conditions are no alcohol or drugs without prescription, no weapons, no firearms. And I wish you good luck, Mr. Basquet. Richard Boyd.
Afternoon, Your Honor.
All right, Mr. Boyd's charged with violating his conditions of release. This is pursuant to a warrant signed by Judge Netcher. He has a private lawyer. What lawyer does he have to be? Okay. All right. So Mr. Boyd has a lawyer on this case. He came in on no bond. State, is he entitled to a bond?
No, Your Honor, it's pursuant to the warrant, so it's the judge in the division who should have set it at whatever they wanted.
Okay. Well, it is a felony, and it is Judge Netcher, and Judge Netcher has indicated his request that bond is set at none, so I'm not going to disturb Judge Netcher's setting of bond. Stay the bond at none. Mr. Boyd has private counsel, and any motions to set bond or conditions of release can be argued before Judge Netcher. Good luck, sir. Next, we have DeAndre Brutus. All right, Mr. Brutus is here on a charge of possession of cannabis with intent to sell or deliver, possession of drug paraphernalia with intent to sell, and possession of greater than 20 grams of cannabis. He comes in with bonds on counts 2 and 3, but not 1. State, what level of felony is possession of cannabis with intent?
F2, Your Honor.
An F2?
Yes, Your Honor.
All right. Does not appear to be trafficking. He is entitled to a bond. I'm going to set, is he qualified for PTR?
No, Your Honor.
All right, on count 1, I'm going to set bond in the amount of $5,000. Stay the bond on possession of paraphernalia with intent to sell at $2,500, and greater than 20 grams of cannabis at $2,500. That's going to be a total of $10,000. Special conditions are consume no alcohol, possess no drugs without prescription, no weapons, no firearms. And I'm going to appoint the Office of the Public Defender to represent Mr. Brutus. Good luck, sir.
Thank you so much.
Malik Campbell.
Yes, sir.
All right, Mr. Campbell. Mr. Campbell's here on a charge of sale or delivery of cocaine and unlawful use of a two-way communication device. State, what level of felony is sale or delivery of cocaine?
It's an F2, Your Honor, but pursuant to the bond schedule, it should be $15,000.
$15,000, really? All right. What about the unlawful use of a two-way communication device at an M1?
I believe that is.
Mr. Campbell, I find probable cause based upon the arrest warrant signed by Judge Johnson. I'm going to set bond pursuant to the schedule on the second-degree felony of sale or delivery of cocaine in the amount of $15,000. I'm going to set bond in the amount of $1,000 on count 2, unlawful use of a two-way communication device. I'm going to require the defendant consume no alcohol, possess no drugs without prescription, no weapons, no firearms. And I will appoint the Office of the Public Defender to represent Mr. Campbell. Monica Carlock. All right, Ms. Carlock is charged with 2 failures to appear. All right, she is represented by a private attorney. Apparently, the capias was issued for her failure to appear at trial management on September 11th. That judge set bond at none. I'm going to stay the bond at none. And any motions directed at establishing bond can be filed with the judge in Division 15 who issued the capias at no bond. Dolores Carter.